Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases and real-life facts and clients. They're always things me or my office have worked on. If names are used, they are of course altered for confidentiality purposes. For today's episode, we're going to be talking about guardianships, and specifically where I've seen guardians slip up and do something wrong. Thankfully, I've not worked on any cases where the guardians have went directly or maliciously against my advice and recommendation, but nonetheless, they've done something that they thought was okay, and it turned out it was really not okay. Hopefully, talking about some of these things will bring awareness to guardianships, like what they are, how they work, what the guardians should and should not be doing as they serve. But let's lay a little groundwork first on guardianships. So let's talk about first what they are, the terms of art that get thrown around, etc. Really before we dive into the stories. So how do guardianships fit into my little estate world? First, we help clients gain guardianship over children who may have special needs. And with turning 18, the child becomes, legally speaking, an adult. So sometimes kiddos who are about to turn 18, the parents or whoever may be the proposed legal guardian want to maintain being the child's decision maker. And a guardianship is the legal procedure to make that happen. And second, we also help clients gain guardianship over aging adults. Most of the time, those adults are experiencing significant cognitive impairment. Think like advanced dementia, Alzheimer's, etc. Where the person, due to their cognitive impairment, needs further assistance with decision making. Oftentimes, we see this become a thing if the person does not have a power of attorney in place, or perhaps their power of attorney document is just not strong enough, and the person trying to help with decisions is hitting roadblocks. Beyond that, there are two types of guardianship. There's guardian of the person and guardian of the estate. Guardian of the person means you have the authority to make decisions about the person. So think like healthcare decisions, where the person should reside and attend school, etc. While guardian of the estate means you have the authority to make decisions on the person's estate or financial affairs. So for this, think like applying for governmental benefits, accessing bank or financial accounts, working with a financial or tax professional, etc. Lastly, before we get into some stories, this is a cautionary tales episode after all, I often explain to clients that a guardianship is something that really never goes away. It has to be maintained. And what do I mean by this? Okay, well, here in Indiana, which I'm sure a lot of states are fairly similar, once a guardianship is established, it's not a set in stone forever sort of thing. We have to do routine reports to the court to provide updates about the person, their finances, their whereabouts, and we ultimately request that the guardianship remain intact for reasons A, B, and C for another couple years. Most counties here in Indiana require us to do these reports every 2 years, though it's a county by county, state by state thing. And they really only ever get, they as in guardianships, really only ever get terminated in 3 situations. First, if the guardianship was intended to be temporary. Second, if for some reason the guardianship just isn't needed anymore, but the individual is still alive. Or 3, the individual has passed away. Though we also are required to notify and or ask the court to do some things outside of these routine reports, like if we want to sell any of the individual's property, if we want to do estate planning, if we want to move the individual. They do all these things because it's the classic bad egg scenario. One bad egg ruined it for everyone. They do it to keep an eye on things, to make sure the guardian is behaving and doing the appropriate things. So while it feels like the court is kind of being nosy, they're involved in all these things because the bad eggs that did bad things. Okay, let's jump to a few stories on where guardians have done things that were less than ideal. The first topic is selling guardianship property. So we helped 3 children become co-guardians of their mother. And side note, I'm not usually a big fan of anything, unless it's like a child's parents, for example. So the fact that they even convinced me to do it, do co-guardianship for 3 children is somewhat of a miracle. In their defense, they've been co-guardians now for a handful of years and it's worked out just fine. I don't mind getting proven wrong when it's in my client's favor. Anyway, Mom had a house, a car, and some financial accounts that, as a product of the guardianship process, we had to disclose to the court as part of the guardianship proceeding. Well, Mom resided in an assisted living community that was not cheap. So we knew it was in the cards to likely have to sell the house. But in the initial stages of the guardianship, it just wasn't necessary at the time. Well, fast forward some time, and my office gets a call that they sold the house and want to know if the proceeds need to go into the guardianship bank account. I stopped in my tracks when my teammate told me this, and I said, "What did you just say they told you?" And she confirmed what I thought I heard. So, long story short, they sold the house without asking the court for approval, which is a huge no-no. That afternoon, I gave one of the guardians a call, and it was the one I normally talk to of the 3. And I explained that, as we discussed, I have to ask the court to sell the house before you do it. Honestly, she said she just totally forgot. I shared that I would prepare a document that I would ultimately file with the court and explain what happened, and that I hope they don't call a hearing. In all honesty, they probably should have called a hearing to give the guardians a little bit of a lecture, but maybe the judge knew I already did that, and the judge did not call one. And I told them that they should go buy a lottery ticket because I don't know why the judge did not call one. I bet they don't do that again. Actually, they did not. They ended up having to sell Mom's car somewhat recently, and they called my office before they did so. Okay, second topic is commingling personal funds and the guardianship funds or guardianship account. So we helped a father and a mother become co-guardians of their special needs son. The special needs son was going to be turning 18 years old soon, so the parents knew to, maintain making decisions on his behalf, they had to seek legal guardianship. And they were awarded guardianship, yay! Here in Indiana, if you become the guardian of the estate and the person's estate exceeds a specific amount, you have to prepare and submit an accounting to the court when you file those routine reports I was talking about. Well, in the accounting, you have to show every penny that has come into the guardianship account and every penny that has come out. And their son had received an inheritance from his grandparents, so he actually had money to his name, and hence we had to prepare accountings in the future for his guardianship. Well, fast forward some time, the report and accounting were coming due soon. So we reach out to the client to get statements for the guardianship account, and we're knee-deep in preparing this accounting. And we see a $4,000 withdrawal. We couldn't figure out what it was, so we called the client and asked. Basically, they were doing mobile banking and thought that they had transferred the $4,000 out of their personal savings account, but instead selected their son's guardianship account. So the $4,000 came out, and they didn't even notice what they had done until I called their attention to it. Immediately, when I called their attention to it, they put the $4,000 back into the guardianship account, hoping to show the court it was just like an oopsies. Well, unlike my last story, This judge was a little more by the book and called a hearing. And I knew it was going to be about that. So I prepped my client, and I basically telling them to apologize, to be remorseful, and definitely do not be defensive. So we go to court, we go to the hearing, and the judge gives them an earful. And we go on with life. Was it fun? Definitely not. Did it cost the client more because they had to pull me in to clean things up? Yep. Will they do it again? Hopefully not. But I bet they're a little slower with their fingers when they're doing mobile banking now. Okay, the third topic is like big changes. So like moving, new assets, new sources of income. What's the saying? Change is the only constant in life, right? And it's so true. Changes in guardianship world have to be reported to the court. And sometimes we have to ask about them in advance. I'm going to start with new assets and income. Those are usually pretty easy because we just send a report to the court saying, hey, Joe Bob has a guardian. Joe Bob has a new asset, and Joe Bob is receiving an additional source of income, and that be it. It's not really even like a petition or a motion. Like, we're not asking the court to do anything. Instead, we're just like notifying them. Though we have to be certain that any new assets do get reflected on accounting if that becomes an issue. Moving though, comes with a very unique set of challenges. Moving within the state is fairly easy. You just have to ask to move them. And sometimes they will want the case transferred to be under the county where the person is moving to. So say the individual currently lives in Hamilton County, Indiana, and the guardianship is, in Hamilton County, but they're moving to Marion County. Sometimes they'll request that we transfer the case to Marion County. Transferring to another state is a whole different ballgame. It is a much bigger process. We have to ask our court to allow it. And if they say yes, you have to establish the guardianship in the new state. And once it's established, we have to terminate the guardianship in the old state. It's a lot of work, for sure. I have stories for all of these. New assets that were not disclosed to us, then we have to ask for forgiveness. Guardians that have moved the individual to another county without notifying the current court. Guardians that moved the individual to a totally different state without consent from the current court. And most cause me and my office to work more, which means more fees. I remember a case where there was a lady that was the guardian of her niece, I believe, and she moved her niece to a totally different state, didn't tell us, and I thought the court was just going to haul her back, to our state and make her get in front of the judge. They didn't, but it was definitely a 50-50 shot. So the thing about guardianships that I tell all clients is that anything that happens to the individual, just call my office and let us know before you, as guardian, do anything. We actually send out a little checklist when we go to do those routine reports to the court. Or before we go to do the reports to the court, we send out a little checklist. Like, has this happened? Has this happened? Has this happened? So it's kind of a cross-check for them and for us. The last thing any of us want to be doing is tucking our tails in to go in front of the judge. I promise, it's not fun for you, and it's not fun for me either. I'd much prefer to stay out of the courthouse. Alrighty, let's wrap up this episode. Next week, we are back to the current events, current trends topic, where we talk about something I've seen or run across, maybe on the news or social media, that I think would be interesting to chat about on here. Next week, we're going to be talking about how to pass on your passwords when you die, which is a topic that is very, very timely as we become more and more and more reliant on online platforms like online banking, electronic statements, social media, emails, etc. So yeah, tune in for that next Tuesday, Legal Tea listeners. Until then, be well and talk soon.